Hi, welcome to Issues of Habitability. We'll get going in just a minute as we get people coming into the presentation. All right, Chris, I'm going to go ahead and go. Okay, well, welcome to the Issues of Habitability. Today, we're going to talk about a lot of fun stuff. And first, I want to introduce our guest attorney, Michael McLaughlin. Hello, Michael.
Good morning, Steve. How are you?
Good. And Michael is a landlord tenant attorney. He specializes with helping landlords resolve their issues. I want to introduce Phil Barthman, our senior building inspector.
Hello.
Phil does a lot of he helps us and does expert witness work. We do a lot of feasibility studies around ADUs and deal with a lot of notices of violation. He's a combination building inspector and spent 20 years at the Alameda County Building Department. I'm Steve Edrington, president of Edrington Associates and Adapt Dwellings. We opine on issues of habitability, wrongful eviction, and go to court on a regular basis. So Michael, I've actually worked for Michael in some crazy cases over the years. So it's
Yeah.
All right. So today,
and I've actually just a shout out to Phil. I've worked with Phil. I think Phil, you were in a rent board arbitration on some habitability issues about a month ago, and I just want to thank you for your participation. It worked out really well for us. So always good to have you and your team on our side. And I really appreciate it.
Yeah. Well, thank you, Michael. We appreciate it. All right. So we're going to cover the Civil Code today, 1941, the Health and Safety Code, examples of violations. And I just want to put out here, we have some gross photos that we're going to show you that we've collected over the years. If you have anything that's grosser or you think we should add to our presentation, always feel free to email those to us. So we're always looking for things that people should not be doing. We're going to talk about landlord-tenant obligations, landlord-tenant rights, wrongful eviction, damages, and settlement offers. So with that said, let's get going here. Little disclaimer, this presentation is an overview and should not be construed as legal advice. Michael's a lawyer, Phil and I are not. Our comments are general in nature and may or may not apply to your specific questions. So we'll take questions at the end, but we just always want to be cognizant that this is an educational session and not a legal counseling session. All right, so what is warranty of habitability? What does that mean? Many of us have heard it before. Some of us are more familiar than others with it. So the landlord has to maintain a habitable condition throughout the terms of the lease. And I explain to landlords, whether you're charging $20 a month or $20,000 a month, it doesn't matter. You must maintain a habitable premise during the tenancy. And this was established actually in the landmark case Green versus Superior Court in 1974. Michael, I don't know if you want to comment on this court case or any other court cases on this.
Let me just add one thing. I don't want to bog us down in too many legal concepts, but it's important to know that this is not an issue of a covenant in the lease. This is what we lawyers call an implied warranty. Even if your lease is silent and doesn't say that you have to maintain the refrigerator and the stove, the warranty is implied in every lease, every residential lease, not commercial, every residential lease. And so even if your lease is a bare bones lease and it doesn't say any of this stuff, you still have to do it. The law implies that warranty into every single lease for residential.
And Michael, I want to add to it, even if you don't have a rental agreement, it's still implied.
That is a very important point. A lot of people are under the mistaken assumption that if you don't have a written lease, a written document that says lease, that you don't have a landlord-tenant relationship. That's not true. Oral leases are enforceable so long as the term is month to month or less than a year. If it's over a year, it has to be in writing. But if it's less than a year, an oral lease is still a lease.
Yeah, for example, I bought a building and the tenant had been there since 1974. He'd gone through about 7 different landlords and there was no lease. He didn't have one, the landlord didn't have one, but he'd been paying rent. And so it was pretty established that he was a tenant. So,
Oh yeah, there's no question. I in fact went to trial on an oral lease going back to almost exactly the same amount of time.
all right. So when we say habitability, warranty of habitability, that includes compliance with state and local building and health codes. It does not include damage caused by tenants, their guests, or pets. We'll talk about that more later. All right, so what's the landlord's obligation? We'll start there. So you must maintain the roof, exterior walls, windows, and doors. So if the wall's leaking or the roof's leaking, the landlord has an obligation to fix it and provide a waterproofed weather protection from the elements. Good working order, plumbing and gas lines, hot and cold running water, connected to a lawful sewage disposal system. I worked on a case once where the landlord was supposed to had connected to the city sewer and they never did. And there was a whole bunch of issues regarding that. So no, you need to be connected to a lawful sewage disposal system.
Right.
All right. Heat. This is a huge issue. And Phil, I want you to kind of talk about some of the things around heating.
Well, one of the problems that people have in their rental units is many times they've got a wall heater that does an inadequate job of heating the entire unit. Depending on where you're at, the temperature needs to be between 68 and 70 degrees. And that doesn't mean by the heater, that means throughout the unit. And many times we get complaints from tenants who are not getting adequate heat from their wall heaters, which can be a real problem. And one of the things that some landlords try to do to mitigate the heat problem is they give them some extra plug-in heaters, and that is not a legal way to heat your home. That's not the legal way to get the minimum temperatures that you're required to have in your properties.
So Phil, some of the things that we've seen in some really old properties that maybe originally the house was heated by the fireplace, and that is not adequate in today's standards. So can you talk a little bit about that?
Well, and then, fireplaces have got so many issues. Especially in the Bay Area, many of the counties have really leaned towards getting away from fires in general, just because of the tremendous amount of pollution that they put out. Now, granted, even on a no burn day, if your fireplace is your only means of heating, you're allowed to burn. But it's just not an adequate way of getting the heat to all the corners of your home. And when you have insufficient heating and ventilation, that also really creates a mold problem, which is another one of the big things that we see tenants complaining about.
Steve, can I add one thing to what Phil says? And this is something that I see in my practice. And that is that very often a landlord is enamored with the charm of their old building. They love it. They think it's charming. And the fact that it has like some fireplace insert that was, up to code in 1930, it no longer fits for the 21st century. Tenants have a different expectation. And so one of the biggest problems I see is landlords are, well, I lived there and it was fine. And now these people are complaining and so on and so forth. And the truth of the matter is that just because it was fine for you or you think that the building is charming does not mean that whatever's there is going to satisfy your legal requirements as a landlord. When you choose to put your property out onto the open market and rent to third parties, your legal responsibilities change.
So it may be charming, but it's still cold, right, Michael?
Right. And you're going to have, the tenants are going to complain, and then they'll have legal rights that they can assert, as we're going to talk about here.
So part of it, another thing is electrical, and I know Phil, this is a big pet peeve of yours. They have a 2-prong outlet, and they put in a 3-prong outlet without without an equipment ground.
And yeah, that's going to be very, very dangerous to people who are plugging stuff in. Grounding is a very important safety measure that we need to have on our homes. Now, there are ways that can be mitigated, and talking to an electrical contractor can give you very good methods that you can actually have 3-prong outlets without having to rewire the entire home. But just putting in 3-prong outlets where there no ground exists, that's a code violation and it's a safety issue.
So Phil, let's just kind of talk through it. So I have a 2-prong outlet, and there's a 3-prong there, and it's not properly grounded. I plug in my hair dryer, and I accidentally drop it in a tub full of water. Do I become ground?
If you're in the tub, you become dead is basically what happens, unless you have proper ground fault protection, which is something that all landlords should be going back on their homes and putting in bathrooms and kitchens and places where water exists, because dead tenants don't make for good headlines or good public relations.
All right. So you're talking about the GFCIs in wet areas, correct?
Yeah.
Kitchen, bathroom, laundry, garage, outside. Okay, great. All right. So building grounds. So if you have your car up on blocks or on milk crates, and you got a bunch of weeds and trash floating around, you need to clean that up. And I know that's a big code violation. We see that on lot of notices of violation. So if you need to keep the area clean, if you need to talk to your tenants about cleaning up their area, so if they have a backyard or something that they control, they need to maintain the premises.
Yeah.
All right.
Can I just pop in here real quickly? This is a big issue. I see this all the time. If you're running a multi-unit building, you need to have an adequate number of trash receptacles for the number of people living in the building. It's not charming to have just one trash can that 14 people are using, because it overflows, and then you're violating the statute. And I see it all the time.
I'll give you an example here in Oakland. A client of ours had a 4-plex, and he had left his dumpster out at the curb and never took it in, and everybody in the neighborhood used the dumpster. So the tenants never had adequate garbage. And so what they were doing is they would open the kitchen window and throw the garbage out the kitchen window. What happened to back up against a creek? And so the garbage started piling up on the creek, and Alameda County came through and cleaned up the creek and gave him a bill for $20,000, and he had to pay it. So you have inadequate garbage and it piles up and the city has to come out and deal with it. Not only are you creating a habitability issue, but you're going to get a big bill from the city. And guess what? They don't use the cheapest contractors.
Right. Right.
All right. Floors and stairways, railings. Phil, this is a huge area about handrails. And I know people get confused on like grippable handrails and things like that. You're on mute.
The mailman came and the dog is going crazy. This is a good picture of a handrail, of a grippable handrail. A lot of people make the mistake of thinking, my house is old. I've got these beautiful old handrails and I don't really want to mess with them. Here's the thing. A lot of the old handrails don't meet modern standards. Now, are you required to upgrade them? And oftentimes, no, they're grandfathered in. Do you want to upgrade them? Again, injured tenants don't make for good public relations and don't make you money. So having grippable handrails so that people actually have a safe way to get up and down stairs is a very important thing. It's an important part of the habitability. Another thing that this picture doesn't show is many times the handrails just end and they don't wrap back to the wall. And so they provide a snagging place where people's clothes get hooked on them, and that can cause trips and falls. And so having returns on the end so that you make sure that you don't have that snag point is another important aspect of a handrail.
So Phil, on this line, let's say I have a building built in 1950 and I have guardrails out on my balconies and they're 32 inches. Is that okay?
So that's an interesting point. There's, into the code, there's not a lot of things that are retroactive back to old buildings. And this is one of those things that there is a retroactive requirement where you do have to raise your guardrails up to a very minimum of 36. And if you're going to take the time to raise them, you really should raise them up to 42. And the intent here is to keep people from falling out of off of decks, off of staircases, places like that where there is a fall hazard. So meeting code there is a really good idea. But again, if you're too low, there is a mandate that you raise it to a minimum of 36.
So
Yeah.
the 2019 building code is 42 inches, but if you are below 36, you're required by the building code to bring it up to at least 36.
Yeah.
Okay.
And just as a legal point on this, if the reasonable landlord would bring it up to 42, even though the code only says 36, and you bring it up to 36, so you're technically in compliance with the code, and someone gets injured by it because it wasn't at 42, and the reasonable landlord under the circumstances would have known or should have known that 42 is better than 36, even though the bare minimum under the code is 36, you could still be liable in a negligence claim. Very important. Just because you're checking the box on the code doesn't mean you're out of the blue if someone gets hurt.
And Michael, somebody can always sue you for anything. Is that
For
correct?
anything, at any time, right? It's a matter of who will win.
Right. Okay. So one of the issues that we see is we go by the property and the mailbox is like all the doors are open, it's destroyed. So you must have a locking mailbox receptacle, and you must have a lock and a deadbolt on each on the front door. And let me tell you another code violation I see all the time. So I see a nice front door with a window glass in it, and they have a double keyed lock. That's a no-no. You have to have a thumb latch on the deadbolt, because if there's a fire and people, are in the back bedroom and they wake up, the smoke alarms and they're trying to get out and they can't find their keys, it's a problem. So if you have that style of double keyed lock on entrance and exit doors, you need to change those to a thumb lock. Or and I believe they make one that's removable or something, Phil, that if you're worried about a break-in.
Yeah, and this is an area where code and the police kind of diverge, because the police are very big on having the double deadbolt, the double locking deadbolt, because they're afraid of somebody's going to punch through the door and then they can open the lock. And that is unfortunate, but from a security standpoint. But yes, having keeping a key in there, is one of the options. People think, oh, I'll just keep the key in there. Well, if you're going to keep the key in there, that's not going to help you from a burglar busting through either, So you just, from a safety standpoint, for giving yourself the ability to escape in case of some sort of an emergency, having a hand openable from the inside deadbolt is really the way you want to go.
Yeah, so I'm looking at, I see 3 panes across and 4 panes down, right? It's a beautiful door, lots of light through. They don't want people to break out the pane and reach around and grab and open it. You may end up having to change the door out in order to be compliant with the fire code and the building code. So just think about that. Remember, we want people to get out, and we don't want people to have to think about it at 2:30 in the morning. All right, so let's talk about tenant obligations. The tenant must clean the place, must take the garbage out, must properly use the appliance and plumbing fixtures, and no destruction, and proper use of the living portions. So Phil, we've been out to a lot of properties, you and I have, and there's mold on the wall, and the landlord says, there's no broken pipe. The exterior of the building is fine, it's not leaking, but this tenant won't open the windows when they take a shower. It's a 1950s building, and if you go back and read the mechanical code, you have to open the window so you get the proper ventilation when you take a shower. So it's January, it's cold, they're taking a shower and they never open the windows, and then they complain about mold. Can you talk about that?
And that's such a common problem, especially in older homes. In modern homes, one of the requirements is that you, in addition to a window, you also have to have a fan, an exhaust fan. And that exhaust fan has to, in fact, be automatically humidity controlled. And one of the recommendations that we make to landlords all the time is say, look, if your tenants are having a mold problem, it's a good idea to add a fan. And they've got, for example, Panasonic is a really good fan manufacturer, and they make a very, very quiet fan. And one of their models has automatic humidity sensing and motion sensing. So it's not up to your tenant to turn on the fan when it needs to. They walk in, they're going to use the toilet, fan's on automatically. It's very quiet. It's not annoying. They're in the shower. It remains on until the humidity level goes down to an acceptable level. this is a great way to mitigate mold problems. And because this is one of the biggest things that we see on just about every complaint is mold issues.
So Phil, the other issue we've seen is we go in and there's just a ton of stuff. I was in a place the other day. You couldn't get to the window to open the window. It was that much personal property in there. And can you talk about that? Because I know it looked like they took like a couch away from the wall or something. There was like this mold print on the wall.
And yes, and again, ventilation is one of the big things that you need to have. When you've got cold walls, and especially in older homes that don't have good insulation, when it's cold outside and warm on the inside, you're gonna get condensation. That's just the nature of the way things go. So having good ventilation in the building will eliminate a lot of that condensation, because if you have condensation, you're sowing the seeds for mold. There's no way that you could eliminate mold from the atmosphere. Mold is everywhere. What you need to do is eliminate the places that mold wants to grow, and that's where there's water. So cutting down on the moisture, having free air circulating. And one of the big things that we advocate for is central heating, where you've got a fan where you're circulating the air through the building. Makes a huge, huge difference in mold.
Michael, I'm sure you see a lot of this. We do lots of inspections and opine for landlords and tenants about habitable conditions. So I'm
Yeah.
sure.
Yeah, on the mold issue, the one thing I'd like to add, and because you guys have done a great job of the nuts and bolts, but as a practical matter, Steve, what I see more often than not is that there'll be litigation over habitability. The issue is mold, and very often, and I mean on more than a few occasions in the last year and a half or so, I've seen tenant lawyers draft their complaints right into the mold exclusion in the insurance policy. And so if the issue is mold, very often the insurance company is going to deny coverage and deny a defense. And you, the landlord, will be on your own in litigation, paying for your lawyer and paying to settle out of your own pocket. So it's a really, really big issue. It's one that it can be very, very costly if you get sued over a habitability mold issue.
So Michael, you bring up a good point. So if you're being sued by your tenant and you tender that claim to your carrier, and your carrier writes you a reservation of rights saying, if you violated the law, we're not going to cover you. Mm-hmm. So can you talk a little bit about, I don't think we have this in the slide, about personal counsel and cumulus counsel, why it's so important to hire somebody like you to be personal counsel, because the insurance company may or may not have your interest at heart. So maybe you can talk a little bit more about that.
Yeah, very, very interesting. I'll try to make this very brief. It's very important to know that there are two overriding duties of an insurance carrier. There's the duty to defend and the duty to indemnify. They're different. The duty to defend essentially kicks in and says the insurance company is going to pay for your lawyer to defend you against the tenant lawsuit if anything in the complaint, even remotely, could be covered by the policy. So very, very broad. They'll pay for the lawyer. The duty to indemnify, on the other hand, to pay out on a claim, either for a jury verdict or a settlement, right? To pay the tenant and settle the case, or to pay a judgment, is very, very narrow. It only will kick in, and the insurance company will only have to pay if the claims in the complaint fall within the four corners of a coverage under the policy. But when the problem arises is that when you have a mix, you've got some claims like to property damage, like my shoes got injured by water and my bed covering and all that, that's all going to be a covered claim. But then they say that mold resulted from that and I had mold, and the insurance company is going to say, well, the mold damage and the mold issues are not going to be covered. And so what happens is that if there's a sufficient amount of tension in between the insured, the landlord, and his carrier, such that the lawyer appointed to defend you is going to uncover facts during discovery that will basically kick coverage out for you, that's an inherent conflict. And so what, under California law, you are entitled, when the conflict becomes serious enough, to hire someone like me, a private counsel, to represent you and to advocate for you in the litigation, separate from the insurance coverage appointed lawyer. And I don't have that conflict. So my duty is I come into the case and I said, no, insurance carrier, the bulk of this case arises from a covered claim. That's not something that the lawyer representing you from the insurance company is getting paid by the insurance company. So there's this inherent conflict there. And that's essentially what CUMAS is. Sometimes if the conflict is so severe and so obvious, the insurance company will have an obligation also to pay your insurance coverage and your CUMAS counsel, sometimes at a lower rate. So you'll have to make up the difference. And there's a number of granular issues that arise from that, but that's big picture what's
Right.
going on.
So, Michael, I would say before you waive your right to CUMAS counsel, call you.
Yeah, and I usually, yeah, exactly. I love playing CUMAS counsel with people because at the end of the day, it's just you want a bulldog in the mediation room to argue with the green eye shade guy in the corner who is not your friend. He's in the same room with you, but he's actually your adversary, and he represents the insurance company, and he's trying to put a lot of it on your plate, and you're trying to push it back on his.
Right. Because I've actually seen where the carrier says, please waive your right to CUMAS counsel. And the answer is don't call Michael before you do that. All right,
Yeah.
let's continue to move on here. Okay, so health and safety codes, 17.920.3 further defines substandard conditions. There's a whole section on lead, but this is a health and safety code that you must meet in the required. And when the presentation today is a lot on state law, there's also local, like in Oakland, there's a local maintenance code that you have to follow too. San Francisco is the same way. So you're not only dealing with state law, but you're also dealing with local law as well. All right, so inadequate sanitation, improper bathing facilities, improper heating, ventilation, dampness, bugs, rats, mold, sewage, garbage, all that sort of stuff. It's inadequate sanitation. And like I said, if you got a better photo, we would love to see it. These are photos that we've gotten over the year. The second one in from the bottom was a mold case in San Francisco that I worked on. And what happened here is the landlord came in and cleaned up the mold. They hired a third party and they cleaned up the mold. And then they said, oh, it's fine. And they just bleached it and everything. What was happening here, this is a building in Chinatown in San Francisco where the brick was in the late 1800s building, the brick was leaking. Every time it rained, water came in that wall and damaged this plaster. This was 2 days before deposition. And they had said they cleaned it up, and we presented this photo at deposition and said, no, you did not clean up that problem that you said you cleaned up. This came back. Right. So Phil, top left corner, you want to talk about the electrical, how that's a hazard?
So anytime that you've got electrical in and around a sink, that's always an issue. If you'll notice in the upper corner of that picture, you can see that the electrical box is open. So again, water and electricity are a very good mix if you're looking to die. Water breaks down the insulative ability of your skin, and it just opens the door to probably fatal electric shock. So it's just not one of those things that you want to be careless or about. It's just too imminently dangerous to do that. And then, especially when you were dealing around sinks, water, places like that, because of just the inherent danger just increases so exponentially.
All right, so this is sanitation.
Can I add one thing here, Steve, that I see more often than not? It's a word of caution, and that is that when you go to remedy, you have an obligation to remedy these conditions, as we've discussed. When you go to remedy this, please use someone who is licensed and bonded and is an expert in this area, not your handyman. Your handyman is going to go and just bleach the mold off the walls, and it may look okay, and he'll might put a coat of paint on it, and everybody walks away. Where the expert is going to look for the source of the leak, and he'll fix the leak, and then we'll fix the drywall, and so on and so forth. But you've got to use somebody who's an expert. If you don't, you're falling below the duty of care. You're acting in what we lawyers call a negligent manner. The reasonable landlord under the circumstances would hire someone who is an expert in this area, and you will follow his plan, not the handy.
Absolutely. And Michael, I also want to talk a little about mold, and I don't know why people don't do this. So when people claim mold, What I would like to see from an expert standpoint, because I've been in deposition, and they asked me, did the landlord meet the standard of care? And if the landlord hires a professional licensed party to do it, that's an expert. The
Right.
landlord says, hey, I don't know, but I hired the right people and I followed what the right people did. But one of the things I see in mold that's lacking is they say, oh, there's mold. They never test that there's actually mold there. And once they do the work, they never test it and make sure it comes back clean. I'd love to see, here's the mold report. Yes, we have mold. We fixed it. And here's the clean report. Because then I can go, then as the expert looking at this and seeing if the landlord met the standard of care, yes, there was a problem. This third party pointed out, we hired a licensed person to fix it, and then they retested the same spot and there was no mold.
Yeah.
It's clean. And if I can do that, see that really helps. So if somebody's saying mold, think of 2 tests, before and after.
Absolutely. You've got to establish that. You've got to draw the full circle. You've got to start here and establish the problem. A lot of people are, and I find this with people, they're afraid of discovering that there's actually a problem, and they want to hide that result. Okay. The fact that you have a problem is not the issue legally. It's what you do about it once you're put on notice of it. Once you're put on notice of it, the next step is hiring an expert. That gets you halfway. Following the expert's plan and protocol and letting him do the work, that gets you 3/4 of the way. The rest of the circle is doing exactly what Steve said. When you're all done, go in and say, is everything that we did here solving the problem? So this place is clear. If you stop anywhere on the circle before going all the way, then you may actually not be meeting the duty of care, the standard of care.
All right, let's talk about structural hazards. We got some really fun photos. In the top photo, this is a 50s, 60s apartment building. And Phil, I think this is your photo, where they stuccoed underneath it. And over time, the concrete, the railing breaks out of the corner and water gets down. Phil, can you talk about, decks? I know there's been some state law changes on this, and this is one of your photos.
Oh, you're on mute.
Here we go. We had a tragedy that really brought this to bear. A deck, there was a party on a deck, and the deck failed, and several people died, and it was very unfortunate. And what was discovered was, and if you look at this picture right here, you can see that this is closed cell construction. And what I mean by that is they built a wooden deck and then sealed it up. Now you can't see that ceiling because it's been removed, but it was sealed up tight with stucco. And basically that envelope created an unventilated space. And so in an unventilated space, when you've got sun and then cold and sun and then cold, again, you get condensation. And if there's no way for that condensation to go anywhere, it's going to stay there, and mold and dry rot is going to take hold and turn a perfectly fine deck or structure into a moldy mess that is about to fail. And in this picture right here, this one is about to fail. It is in desperate need of a complete rebuild, and that's going to be expensive, because if you look at the way that this is built, this is a cantilever deck. And so every one of those joists that you see coming out extends into the unit 2/3 of the full length. So this sort of thing is going to create a big impact on the entire building as far as construction and tenant move out, or it's going to affect the tenants in their units. So this is a thing that the building departments are really strongly looking for. And again, dead tenants don't make for good PR or positive cash flow. And so it's something that you really need to be careful about.
And Phil, I want to talk about dead tenants, because you and I worked on a case where 2 tenants died in the building. The challenge came to, when it came down to it, the issue was the insurance offered to tender the full policy, but it wasn't enough. And I think they had a $500,000 policy, and the plaintiff was asking for $2 million. So the insurance company said, we'll give you the $500,000. So the argument was, what was the landlord going to contribute? where was the landlord going to come up with that other $500,000 or $1 million that they were trying to say? So yeah, if when people pass away and you're liable, it's going to be you're going to be losing your house, you're going to be losing your retirement savings, a bunch of other stuff. I'll give you an example, and this is a famous, a very infamous case, was the ghost ship in Oakland near the Fruitvale BART station.
Mhm.
The city of Oakland paid out $36 million on that case. And if there was 36 people that died in that fire. If you're the landlord and you have a $2 million policy and you have, say, a $5 million umbrella, that's not going to be enough. They're going to take everything you have. So you got to take the stuff really, really seriously. I want to
Steve,
talk about.
can I add on that, but just very briefly? I bang the drum on insurance all the time. Whether you have the right policy in place and whether you have adequate limits is actually a financial planning issue, not a legal issue. So people very often say, is this enough? And I am a lawyer. I do not know whether it's enough because I don't know what you're worth. I don't know what's in your bank account. I don't know how much real estate you own. But I will say this to people: you need to consult with your financial planner. Your financial planner should be in touch with the insurance carrier, and your financial planner should tell you what limits you should have. How big should your umbrella policy be, and so forth. That's not a question for a lawyer. It's a financial planning question.
Oh, I agree. I want to give you two other things. Stairway, the top right corner is a stairway. This actually stairway proceeded out past the roof line, and the step got damaged. It was a trip hazard. And then on the bottom left corner, this was actually a case I worked on. They started scabbing extra wood. I would not walk on that stairwell. It was that dangerous. And Michael, I got a funny story on this for you. Michael and I are involved in this networking group called Provisors. And the lawyer that deposed me, I met him at a Troika where we met him. And I said, I didn't remember him. And he said, Steve, I remember you. I said, where? He said, I deposed you in this case. And he said, and I said, well, how did I do? And I said, well, he said, you did really well because you convinced us that our rent damages were zero. The place was so bad. And it was these sort of things like this where you couldn't even walk down the stairs. It was that scary. So, but anyway, it made for some good photos for our presentation. All right, let's talk about weather protection. Broken windows. Actually, this middle one here was the same project of that stairwell. The roof was so bad you could see daylight through the soffit, and the floor was so bad I was afraid to go out on the middle floor, afraid I was going to fall through to the first floor. So just some really crazy stuff. Top right corner is actually a commercial property over in Sausalito. Every time the tide came up, all the water leaked into these commercial places, and this commercial tenant sued the landlord because she could never open her business because the water kept coming into the building. So pretty crazy stuff. All right, lead hazards. This is a big issue. The picture on the right is a project we worked on in Oakland. It has a bunch of peeling paint. But Phil, I wanted you to talk about windows and lead hazards in windows.
On old casement windows, one of the reasons they're a very big lead hazard is because when you open and close those windows, particles of dust that comes from those windows gets into the air. If that's lead-based paint, then you're basically getting lead-based dust in the air. So having upgraded windows from so many areas is a great idea from an energy standpoint, from a comfort standpoint, from a noise reduction standpoint. They're terrific, but the fact that you're getting poison out of your household is a really big one as well. Now, if they're doing that, you want to make sure that they're mitigating the hazards. You need to make sure that maybe the paint has been tested, or that they're at least doing a very good job of cleaning everything out, vacuuming, and making sure that you're coming home to a clean, safe house after this job has been done.
I want to point out another thing, and I saw this get quoted by code enforcement. Before you start tearing apart a house, especially with a tenant that's occupying the house in a pre-1978, you should be checking for lead and asbestos. And there's cheap, easy ways. There's a lab over in Hayward. You can cut a little piece and put a little sandwich bag and ship it to them, and they'll test it. But if you need to test and make sure that you're not, when you open up the wall and you pull all that old drywall off, that you're not exposing the occupant to lead and asbestos.
Right.
And there's a civil code, and I don't have it, but it's in but I came across that recently, and the law specifically says if you have a pre-1978 house, before you start tearing it apart, you need to check and take adequate precautions. So what do I see? You know, old lead base paint, popcorn ceilings, right? Hey, I hate the popcorn ceilings from the 60s, right? And I'm just going to wet it down and scrape it off, right? Well, a lot of times that stuff's full of asbestos, and that stuff not only is hazardous to your workers, but hazardous to all the occupants. Those are big issues. So just take some adequate precautions. Before we tear into, especially popcorn ceiling, we'll just go in the closet, cut a little piece, put it in a Ziploc, send it over to the lab. They send us a report. Hey, it's clean. So then I'll tell my guys proceed and take it out. But we've had them come back where they were asbestos, and they come in and we hire a special asbestos abatement company, and they double wrap the inside and put negative air pressure, and then they wear these special suits and they wet it all down and roll it all up. Yeah.
And Steve,
Don't take it seriously.
There are statutes, and just from a legal perspective, there are statutes that govern how to deal with, you know, doing construction with lead and asbestos. If the statute exists and it tells you that you have to do something, right? You have to get it tested, you have to do something, and you don't, but you do everything else that's would be super reasonable, right? Like you think you're doing such a great job, but you don't follow the statute. That's what we lawyers call negligence per se. If the person who's intended to be protected by that statute, for example, the tenant, can sue you for negligence, even if you were acting, you hired an expert, but the expert, let's say the expert fell down on the job, didn't do it right. So you act in every which way that you think is reasonable. You put tarp up, you did a bunch of stuff, right? You had lots of activity, recognizing there's a problem, but you violated the very specific statute, your negligence per se. And you can get sued for that with all the statutory damages. So very, very important when you're dealing with lead and asbestos to check the civil code and make sure that you're following exactly what the code says you need to do.
Right. All right. Let's keep talking about other hazards. All right. So the bottom right corner one wins the award. And we actually saw this on another property the other day. So what somebody is doing is they've taken the panel, they've opened the panel and they jumpered wires on it to move power somewhere else. And we saw this the other day. Phil, you might want to describe this thing that we saw the other day, or you saw the other day.
Yeah, so apparently at some point in time, somebody had felt that they were going to put in a duplex power, but they hadn't legalized the duplex. And so they had basically 1 meter on and an exposed meter service. After that, they had actually opened up the door and gotten rid of the dead front and then hooked up a wire and then hooked it onto some Romex where they could have power out in the front yard. And it just was nicely coiled there hanging from the fence. So we had open, exposed, live electrical. We had wires that were just jumpered on. Half the house was actually stealing power from PG&E because they'd jumped across the jaws on the meter section. So it was a big red flag. And the corporation that owned this place was probably unaware of it. So that was one of the big things that we wanted to let them know. Hey, don't think about adding an ADU to this place until somebody sorts this electrical out, because it's an imminent hazard and definitely a habitability problem.
Yeah, you have this, you're gonna get a red tag notice. If the code enforcement comes out, you're gonna get a red tag notice. It's just crazy. All right, bottom left corner. I put a picture here, but this is a missing smoke detector. So you need to put smoke detectors in all the bedrooms, all the adjoining rooms, and a carbon monoxide detector on every floor, that if you have any gas appliance or you're over a garage. So Phil and I worked on a case, and 2 people died of carbon monoxide poisoning. And then the question was, where was the second smoke detector on the top floor? And nobody could find it. So you do not want to do that. And I just want to point out, if there's directions that come in a pack, please pull those out and read them. and install them according to the manufacturer's specification. Because when we went back and looked at the health and safety code, it said landlords need to follow the building code or the manufacturer's install instructions. So I mean, the average landlord doesn't know the building code, and I understand that, but we all can read directions. So don't just, pull the pack out and put them in there. No, read the directions, and how does that manufacturer tell you how to install that smoke detector and that carbon monoxide alarm? So this is very, very important, because I know we kind of like gloss things over and we don't think about it. But please, when all else fails, what did they say? Read the directions. All right, Bill, do you have any other comments on that?
I was just going to say, I teach an electrical code class at Laney College. And one of the things that we talk about in my electrical code class is when you're installing listed products, and you should be looking for listed products. And the listed products need to be installed per the listing. How can you find out what the listing is? Read the instructions. That is how you discover how experts have examined these things, tested these things, and ensured that they're going to operate in a safe way and the correct way. In the example of the carbon monoxide alarm, where people had a functioning carbon monoxide alarm in their home and they still died of carbon monoxide poisoning. Well, yes, they had one, but was it installed per the installation instructions? No, it was not. And it didn't adequately protect those tenants.
And when we say that, we're looking for that little UL sticker, correct?
UL, ETL, there are a number of different nationally recognized testing labs. Most of the time, it's very rare that Home Depot or a hardware store is going to be selling unlisted electronic safety devices. Very, very rare. They do sneak some in every now and again, and Underwriters Laboratories is a big advocate for making sure that you don't get counterfeit products. They do quite a good job of policing that stuff. But checking for the UL label is a very easy thing that you can do to ensure that you're getting stuff that meets minimum standards.
All right. So all else fails, read the directions. All right. So let's talk about nuisance. Michael, I want to kind of get your thing, but if you have people turning tricks out front of your building, selling drugs, noise, smell, sewer, general uncared for stuff. Actually bought a property where there was a drug dealer, and we put up cameras, and they were literally doing, they just had a lot of friends that showed up for 5 minutes and took off, but it went on day in and day out. And I literally saw a drug deal happen right in front of the camera. I don't know what they were thinking, but
Right.
baggie went out, cash went in, pretty crazy. So Michael, I want you to talk a little bit more about nuisance, if you can. The nuance of nuisances.
Yeah, and I've actually taken these cases to trial, nuisance cases, jury trials. So essentially a nuisance is, and the most time it comes up for landlords is, you'll have one tenant that is conducting themselves in a way that we lawyers call interfering with another person's quiet enjoyment. It comes up in a number of ways. Loud music in the middle of the night, smoking is a big one. Having children running up and down you live above somebody else and there are no carpets on a hardwood floor. So that's a big problem. Anything that's going on that interferes with somebody else's peace and quiet essentially is going to open you up to a nuisance claim. Now, as a landlord, you might have an obligation to, let's say you have a multi-unit building, you might have an obligation to one of the tenants to stop the other tenant from creating a nuisance, from engaging in conduct that's interfering with the other tenants. It's the covenant of quiet enjoyment, which is like the implied warranty of habitability. It goes along with every lease, whether it's in there or not, whether it's stated or not. So you can find yourself in litigation where you're essentially having to defend yourself for what you did to try to get one tenant to stop bothering another tenant in what they did.
Okay, great. All right, so I just got a text that we are running over on our presentation. So we'll continue to move forward. We're going to stay and answer questions. So I'm going to move forward some of the slides. I apologize. We got stuck talking about crazy looking photos. So Habitability issues a limit and it limits the landlord's right when all the following true are the left. So when all the following lacks previously covered characteristics deemed substandard by a local inspection office, landlords receive written notice, the issue has been going on for more than 35 days, issue is not caused by the tenant. That landlord may not demand or collect rent, increase the rent notice, or issue a 3-day notice. So if code enforcement comes out and gives you a notice of violation and it goes for more than 35 days, you cannot collect rent, issue a rent increase, or demand rent a 3-day notice. Doing so may be a lawsuit may be brought by the tenant, and you may be liable for damages and attorney's fees. So, Michael, I know you see this all the time, but we want to.
Yep. If you get a notice of violation from the building department, you got to move on it immediately.
Immediately, all hands on deck, deal with it. So, tenants can withhold rent. There's a bunch of court cases on this. So, if you're not in compliance, the tenant can withhold rent. Constructive eviction. So we see a lot of this. So it occurs when tenant is forced to vacate because the conditions are so bad that they can't live there. So the landlord has breached habitability, the landlord has breached quiet enjoyment, and the damage could be rent differential. Hey, I was in a rent controlled unit, I was paying $1,000 a month. You were running the jackhammer 24 hours a day down in the basement. My windows were vibrating. I couldn't handle it. I couldn't sleep. I couldn't go to work. I had to move out.
Yeah.
I lost my rent controlled unit. Fair market rent's $3,000 a month. It's $2,000 a month in rent differential damage. I was going to live there for 10 years. And then
in the local rent control jurisdictions, Berkeley, Oakland, and San Francisco, those rent differential damages is the difference you paid between the rent control and what you got on the market, times the number of years that you can prove you'll be there, trebled. And the other thing too is you need to check with your insurance policy to see whether you may have wrongful eviction coverage under the policy, but you need to understand what it's actually covering you. It's not a legal question. This is going to be a question for your insurer. Are they going to pay the statutory trebling? Are they going to pay the attorney's fees? Because that's where the money is. That's where, the tenant lawyers come in and they sue you and they triple the damages and they get attorney's fees, and suddenly you got a demand for over $1 million. And the insurance policy, even if you have a $2 million policy, they may say, well, we don't pay for trebling. We don't pay for attorney's fees. You need to check that.
Right. And then the other thing, overpaid rent. So if you have an illegal unit, and I'm working on a case right now, the landlord tenant got along fabulously, tenant stopped paying rent, landlord issued a 3-day notice to pay rent or quit. And they went to a tenant lawyer, and the tenant lawyer says, you don't have to pay any rent. It's an illegal unit. They don't have a proper certificate of occupancy. Now they're demanding all the rent back they ever paid. Okay, that's just craziness. You don't want to be there. Yep. All right. Attorney's fees and written agreements. Some of us have attorney's fees, but a lot of things in the civil code in the local statute provides for automatic attorney's fees. So just because you say it's not in my rental agreement doesn't mean that you won't get in trouble and have to pay the tenant's attorney's fees. So I'm going to skip 998 because this is more technical, but this is something that your lawyer is going to work with you at settlement. Retaliatory eviction, I want to talk about this. So if the tenant is paying $20 a month and they call you and say, hey, my toilet's backed up, you can't say, hey, your rent's cheap, deal with it, and click on the phone, right? So you can't do that. So you must maintain habitability. So if the tenant has called and said, hey, my toilet's backed up, you went out there 3 times and they were putting things down, you can't retaliate. So if the tenant has made a written or oral complaint or filed a complaint, or there's been an issue of a citation, filing of documents to do a legal proceeding, or have a judgment, for 180 days, the landlord may not evict tenants, raise rent, decrease housing services. It's presumed. I'm not saying the landlord can't overcome it, but it's presumed that the landlord's retaliating. And if they can prove that you're retaliating, there's civil damages, potentially punitive damages, and attorney's fees. So if the tenant has complained and you now start an eviction process, it's presumed that you're retaliating, and it's on the burden of proof is on you to prove that it's no, I'm not retaliating because he called me 3 times about his toilet. I'm evicting him because of bad behavior. Michael, you might want to.
Steve, one thing I want to add to this. Yes, that's the statutory retaliatory eviction statute. So what if you say, okay, I'll wait 181 days, then he's out, right? He's out. No, not necessarily. No, there's 2 bases for retaliatory eviction under California law. There's this civil code section right here, which is your statutory retaliation, which is the burden shifting, right? It raises a presumption that you can rebut if it's done within 180 days. But you need to understand there's also a common law retaliatory eviction, which basically does not limit it to 180 days. If the tenant goes in and convinces a jury that even though it was 185 days later, you were doing it to retaliate against him for complaining about the condition of the property, he might still have a valid defense. So it's not enough to just wait that 180 days out. That may get you past the statutory defense, but not the common law defense.
All right. So retaliation equals bad, right?
Very.
All right. Attorney fees for retaliation. Yeah, you don't want to do that. There's multiple damages and habitability cases, general, special, relocation, rent differential, punitive damages. So punitive damages are a little tougher to get. They have to show that you were arising from oppression, fraud, or malice. You were out to get that person, and you behaved in a certain way to get them. So punitive damages are tough. All right, so we're talking about treble damages. So here's what people don't realize. The jury is never going to hear about an automatic attorney's fees and treble damages. They're going to think, oh, the landlord wrongfully evicted this tenant, and maybe it's $10,000 worth of damage. So it's not that much damage in the whole grand scheme of things. But what they don't tell the jury is it's times 3, 30,000. And then the attorney sends in a bill for 100 grand. So those are things that are really, really real out there, and people don't understand it. All right, DeLisi versus Lamb. We'll talk about this. This was a case where there was $110,000 of economic damage, $10,000 emotional damage. It was, but when they got done and trebled it and added attorney's fees, it became a $500,000 bill for the landlord. All right, so let's quickly add wrongful eviction. This is an area that right now, statewide, we have just cause eviction on everything. Many of your local jurisdictions, Oakland, San Francisco, Berkeley, have their own set of laws. So you not only have to follow the state, you have to follow the local. Examples of wrongful eviction. The landlord said, hey, I'm going to move in the house. They gave a termination of tenancy under 1946, and they never moved in. Improper or fraudulent Ellis Act evictions, retaliatory eviction, constructive eviction. And Michael, I want you to talk about constructive eviction because this is a very popular thing to sue on these days.
Yeah, well, you touched on it just a minute ago, Steve, but let's be really clear of it. An actual eviction is when I serve you a notice terminating your tenancy. Let's say it's a 60-day notice, and if you're in San Francisco or Oakland or Berkeley, you've got to state one of the recognized just causes. That's an actual eviction. That's one that you actually terminated the tenancy, you did it properly, you served the proper notice, you stated the proper purpose. A constructive eviction is essentially this. When you are put on notice of a dilapidation in the property, and the dilapidation is substantial, it's not just, it's something minor, like the toaster doesn't work. It's some major component of the thing. The plumbing is out or the heating is out. You, the landlord, on notice, and after a reasonable amount of time to fix it, don't fix it. You either say it's not a problem, tenant, deal with it, or you just you ignore the request. And the tenant, after a reasonable time for you to fix it and you don't fix it, they just decide they can't live there anymore because it's too cold at night to sleep, and they leave. You, the landlord, might say, oh, I got rid of that problem tenant. This is great. No more problem. But 4 months later, they're going to sue you for a constructive eviction. That's what a constructive eviction is. You didn't actually go in and serve a notice terminating the tenancy, which is an intentional eviction, right? You intended to do it and you did do it, and you're okay if you had just cause. A constructive eviction is where you breached your duties to the tenant to the degree that it was unbearable for them to stay there. So you didn't actually tell them to leave, but they had to leave because of your conduct. That's the difference.
Right. No, absolutely. Absolutely. That you created an environment that was so terrible that nobody in their right mind would want to live there. So,
Right.
All right. So we're at the end of the presentation. Michael, as always, we could talk for 4 hours about this probably.
It's a good thing I love my profession, Steve, because I could talk on this stuff all day.
Yeah, that's the problem. We could talk all day. So if you need to get a hold of Michael McLaughlin at McLaughlin Sanchez, he does evictions, tenant buyouts, HOA disputes, real estate disputes. This is his number. Michael, you're on our preferred attorney list on our website. So if you go to resources on our page, you're prominently on our list. So please give him a call. And Michael, you're doing webinars and other things, so people will want to get on your web as well. So a little bit about us, and then we'll go to questions. Phil works for me. He's our building inspector. I'm also a building inspector, but Phil has more experience. But I opine on standard care for landlords. I'm a CPM, certified property manager, been a landlord for years. So we go to court and we opine about wrongful eviction, standard of care, warranty habitability, and talk about damages. In addition, we do a lot of work around illegal units, and the state law has passed recently that now creates a pathway to legalization in that unit that you could never legalize. We work with a lot of clients that want to add or legalize units, code enforcement, notices violation, and we also represent people at the rent board, do some condo conversions, although that's getting smaller and smaller. We're also a real estate broker. I started my career as a real estate broker working for a company called Grubb & Ellis selling apartment buildings. So that's many years ago. So with that said, Chris, before we go to questions and answers to our Q&A piece, can you tell us what other programs we have coming up?
Yeah, so our next upcoming webinar is next week, the 25th of February, on accessory dwelling units. And then we'll be doing that again on March 29th for people that can't make that February date. We're also working on doing this habitability presentation again in mid-March, and we're still confirming the date of that. Also, for anybody who's a member of the San Francisco Apartment Association, we will be doing a habitability webinar for those members on March 16th.
And,
All right.
and Steve, can I give you a shameless plug? Because
Sure.
I think the work that you and Phil do is so critical. As a lawyer advising landlords, I'm really attuned to this. I'm going to give you a really quick example where tenant complains of a lack of a ventilation in a kitchen. And the question is, he was claiming that it was a building code violation. And I'm a lawyer and not a building code expert. And so I hired you and Phil to come in. And Phil came in and took a look at it and realized that it was grandfathered. And so we actually weren't in violation. Super, super important to get an expert like you and Phil in to answer that question, because as a lawyer or a landlord, you don't want to just argue with the tenant, say, yes, it is, no, it isn't. And you get into this where nobody actually knows anything. So it's really important to get an actual expert in the subject matter to come in, because when Phil came in and gave me an expert report that said, I'm Phil, I've been a building code inspector for 40 years. I came to the property on such and such a date. I took a look at it and this is the basis for it not violating the code. We won the case because Phil is the actual expert, and we can actually put that evidence in front of the finder of fact and get the decision in our favor. If you don't do that, if you don't make the investment in your services and Phil's services, chances are you're going to lose as the landlord. The tenant's going to complain about it. If you don't have an expert to tell you that you're actually in compliance because you didn't want to spend the money to actually get the expert out there to render the report, you may very well lose the case when you shouldn't have. So thank you both. I use you guys all the time. I think it's super important that you are in my network. And I just want to tell people, if you get into a situation with a tenant where they're making a claim that you're violating the building code in some, don't guess. Don't go try to read the building code yourself. You got to hire you guys to come in and actually do an expert investigation and report.
Michael, thank you. We appreciate your referrals over the years, and we send people back to you. And hey, there's a lot of lawyers out there, but Michael's one of the competent ones when it comes to landlord tenant. And I tell people, don't hire your friend's divorce lawyer. Michael is a specialist in landlord tenant, and he's going to save your bacon. And picking up the phone and calling him and paying him for his time to help you is super important. So thank you, Michael. With that said, I would like to go to the questions.
All right. And I know that Michael and Phil both have appointments coming up. So if you guys need to hop off at any time, please go ahead and do that. Okay, so our first question is, what can a landlord do if a tenant who is elderly refuses access to the unit for repairs due to COVID?
Oh, that's a great question. That's a really, really good question. My advice to people right now is to follow the CDC guidelines as far as entering the property. Follow all the protocols. The long answer is that under the civil code, you have a right to go in and inspect the property if there's necessary repairs that need to be made, or to exhibit the property to prospective purchasers and a few other reasons. If they refuse to allow you access, the remedy for that under the rent control statutes is you got to warn them to cease doing it. Then you got to reserve the notice. If they block you from access again the second time, then you have a just cause to evict them. But honestly, and as a practical matter, that's a long, drawn out process that is just not going to get you, by and large, where you want to go. And because it's probably sometime in 2022 that you'll get that case heard. And maybe a jury will evict them for that, and maybe they won't. I've actually done evictions for this in the past. So it is a just cause. But as a practical matter right now, I'm telling clients right now, if you want to get a prospective buyer in and they say no, you're I hate to say it, but you're really stuck. You really got to try a little bit of honey with people than vinegar, because yeah, you can file an unlawful detainer action against them if you all follow all the rules, but you aren't going to get that heard, and it really isn't a practical resolution right now.
Michael, I know we go out and we're on site inspections, and we take caution to mask up, and so I think one of the things is having a protocol, and if the person's concerned about you breathing your COVID cooties on them, having a COVID protocol, because you might not be able to get the buyer in, but you might have to send in your heater repair guy to repair the heater, for example. Right. And making
here's kind of a law on this, is that you basically, under the law of negligence, your conduct is going to be compared to what the law calls the hypothetically reasonable landlord under the circumstances. So imagine the perfect landlord, and your conduct has to match his. If the perfect landlord would do a little research and find out whether the county or the state or the CDC has a guideline about what workmen should be doing or realtors should be doing to enter the property, you want to make sure to follow that, do the proper research, find the standard, follow the standard. If you do that and still somebody gets hurt and they sue you, well, your conduct, you had a duty of care, and if you followed the protocols but still somebody got hurt, your liability is unlikely because you were acting in a reasonable manner. It doesn't mean that there's zero risk in life, but you have to make sure that you're actually following what the hypothetically reasonable landlord would do under the circumstances. And in this case, I think it would be, you'd find out if there are any standards promulgated by the local health authorities or the CDC or the local real estate bureau, whoever it may be, and follow those guidelines. Don't make it up. Well, I said, an N95 mask was good enough. Well, what if the local health department said, we now know that double masking is better and everybody should double mask, but you didn't? Well, you might not be, your conduct might have fallen below the standard for the hypothetically reasonable landlord under the circumstances.
All right, great, thanks. Chris, next question.
All right, next question. If a tenant brings a habitability issue to the rent board, can the landlord be allowed some time to remedy? What's the recommended steps for the landlord to take?
Great question. The answer is yes. If you get, normally this comes in a reduction in housing services petition. You go to the rent board. The rent board will, they will basically, if they find the tenant's complaint has merit, then they will basically order a rebate in rent going back to the date that you were first put on notice, and give you, and then allow that rent rebate to go forward through the date that you fix it. So if it takes another 3 months to fix the problem, they'll allow the tenant to, discount the rent on a going forward basis until the problem is fixed.
Okay, great. Chris, next one.
All right, next question. How does the landlord prove that the tenant is not keeping the apartment clean? If I give an inspection notice, won't the tenant just clean up for that day?
Yes, it's possible. These are always issues of evidence, and just remember that when you can't do just a roving inspection inside a unit just because you want to check on an annual basis or so forth. So the answer is yeah. As a practical matter, it can be very difficult to prove that the tenant is doing something that's creating a problem. Here's generally how this comes up a lot in mold. A lot of people want to prove that it was the tenant, the way the tenant was maintaining the property, that was the mold. Well, if you get a mold report, or you become aware that there's a mold problem, let's say the next door neighbor complains about it, and you locate the problem in this unit, you can get in, and you want to get in with an expert and have the expert mold remediation company tell you. They will usually tell you, we didn't find a source of a leak, and more often and more likely than not, it was caused by lack of ventilation, which is a tenant controlled problem.
Yeah, I want to comment on mold. They make an infrared camera. You can look at the wall and look at different things and take photos and put that in evidence as well, which is helpful.
Yeah.
All right, Chris, go ahead.
Okay, next question. For an owner with $30 million in net worth, must they insure a fourplex to $30 million in liability insurance?
It's an excellent question. That's actually a question for your financial advisor. So you definitely want to consult with your financial planner and make sure that the limits that you have in your umbrella policy and your underlying policy match your financial condition. That's actually not a question for a lawyer.
Right, I agree.
All right, next question. What about a resident who cannot stop smoking? Is the landlord guilty of a breach of habitability?
If the tenant won't stop smoking and it's bothering another tenant in the building?
Yes, it sounds like that's the question.
Yeah, that's an excellent question. And actually and Chris, I'm just going to riff a little bit on this as well, because Dana Sack actually raised a really good question on the implied, the implied covenant of quiet enjoyment. Here's the way this works out is that, let's say you have two tenants that live next door, one's smoking and it's bothering the non-smoking tenant. Well, you might have a duty as a landlord to get the smoking tenant to stop engaging in that conduct, because you owe a duty to the non-smoking tenant to allow her to live in her unit without being interfered with. That's essentially what the covenant of quiet enjoyment means. And so you might have to go in and warn the smoking tenant and even ratchet it up, and take all the steps that a reasonable landlord would do. And if they don't stop and they continue to engage in nuisance conduct like that, you might have to try to evict the smoking tenant.
So Michael, I know I'm just thinking about Oakland passed a smoking ordinance, and I know the state law says no smoking in common hallways. I think it's 25 feet to a door or window. So the landlord needs to say, hey, the smoking section's out back more than 25 feet. And I believe Oakland's ordinance says you must identify the smoking unit. So if you have a guy that smokes in unit 2 and he's been there for 30 years and he chain smokes Marlboros, 3 packs a day, I think you may have an obligation to tell other people that are moving in that unit 2 is a smoking unit.
Yeah, it's super. That's a disclosure issue, Steve. But I want to hit on one thing too that you just said, that about the statute in the common areas. That's important. But it's very important to realize, and I had another lawyer call me up to verify this recently. The nuisance, the prohibition against conducting yourself in a manner that interferes with the quiet enjoyment is it is a matter of law. It is not a matter, it might also be a covenant in your lease. You might have a lease covenant that says no smoking. If you're smoking, you're violating you have a contract basis for terminating the tenancy. But separate and apart from that, even if the lease was oral or the written lease doesn't prohibit smoking, if you're doing some conduct on the property that interferes with somebody else, that is a basis to terminate a tenancy, perhaps, that is separate and apart. It doesn't matter whether the lease says it or not. Whether the lease is silent or not, you can't conduct yourself in a manner that interferes with the quiet enjoyment of other people on the property.
So Mike, I want to take that a next step. So let's say that somebody says, hey, I'm smoking cannabis and I need it for my glaucoma or whatever they need it for, right?
Yep.
They can't sit out on the back porch and smoke a joint to the detriment of the person above them.
Well, yes. So you might have to engage in what lawyers call reasonable accommodations, right? But it's like, here's the perfect example for encapsulating that very question, Steve. Let's say that you have the right to either a comfort animal or a service animal. You might be able to have, say, that service animal in a multi-unit building, even though there's a no pets policy, right? As a matter of a reasonable accommodation. However, that doesn't mean that you don't have to pick up the feces and waste in the backyard, right? Even though you're legally allowed to, let's say you're legally allowed to smoke medical marijuana, you can't do that in a manner that actually interferes with somebody else's quiet enjoyment.
Right. So if your dog's vicious and biting people, that you might have to get a different service animal.
You might, because the fact that, and you can't just have a blanket prohibition saying no pit bulls. It's got to be particularized for this particular animal. But if you're a tenant and you have a right to have either a service or a comfort animal, you're still going to be liable for cleaning up after it, for if it goes wild and bites someone or so forth. It's the fact that you were allowed to have it because of, say, a medical condition does not absolve you to run wild through the building with it.
Right. I do think that Southwest Airlines did cut it off at Peacocks, though.
Yeah, and by the way, and this, I don't mean to, this is kind of a joking matter, but not really a joking matter. There now is some effort I see in society as a whole of reining this in. For example, some of the airlines are now saying, there's a limit. You can't bring a snake or a reptile that's your comfort animal onto an airplane. So there is some effort, I think, and we'll see a lot of that grow, sort of this backlash against, just this free for all that we've seen in the last 20 years.
Right.
All right, next question. What is the landlord's responsibility for homeless people occupying the front sidewalk, living in tents, noise, and spreading garbage in front of the building? What are the remedies for the tenant?
Well, that's a really, really difficult and really hard question to answer, because generally speaking, you as the landlord are only liable for the things over which you have control, right? So if they're out on the sidewalk in front of your building and the tenants complain, well, you as a landlord, you might not have it. What I would recommend is take it to the city, do what the reasonable landlord did, make a complaint to the city and see if the city can do it. But if you don't own the space where the homeless people have set up a tent across the street or on the sidewalk in front of your building, it's not your property. You're going to be in a really tough position to actually do anything about it.
So Michael, I want to comment here. So let's say the tenants are complaining about, hey, the trash and the noise and all this stuff. What I see problems with landlords is lack of documentation. So let's say the proper remedy is calling the city and filing a complaint. Write it down. Hey, on Thursday at 2:30 on blah, blah, blah date, I made this phone call. I followed up with an email. I did this. So when the issues come in and the tenants sue for, hey, lack of quiet enjoyment, then you produce in the record and say, you know, I called these guys 28 times. This is what I did. I mean, I didn't ignore the situation. I followed up on it and documented. I
Yeah.
recently was at a property and the tenant said something weird to me. I went home, wrote myself an email and documented that conversation. So if they ever come back and say, well, we discussed this, this, and this, no, that may be true, but I wrote down a note. So documentation is hugely important. And I see when we come in as the expert, I recently worked on where the tenant documented like 117 cases of interaction with the landlord, and the landlord had zero documentation.
Right.
This is super important. If you're trying to deal with a problem and you may be having difficulties dealing with the problem, document that, hey, I contacted the city of San Francisco 28 times. Here's what happened.
Yeah. Generally, the law, and without digressing too deeply into the law, generally the law will not hold a landlord or another person liable for the independent third acts of other people, the independent criminal acts of a third party, unless generally they're foreseeable. And so, for example, you're not liable for a criminal act on your property unless it was foreseeable. So if you're in an urban area, it might be foreseeable that someone will do. So you might have to secure your property more than you would in a rural area. This is a facts and circumstance type situation. So, for example, like the homeless encampment, right, on a property that you don't own, right, in the city. Well, you're relatively powerless to evict somebody from a city sidewalk because you don't own it. You don't have standing to bring that claim. There might be disclosure issues. You might have to tell a tenant, listen, we have a homeless problem. We live in, the Castro, and there's, if frequently the homeless shift around, and sometimes you might see this, right? But you're not the guarantor against the entire world. So there are limits. The law recognizes limits. And it really is, I hate to say this and be a Weasley lawyer, but it really is every case facts and circumstances test, right? It really is going to depend on that particular fact pattern.
All right, next question, Chris.
All right, next question. Front room window panes have condensation causing mildew. What is the remedy? Will double pane windows prevent condensation?
Yeah, my recommendation in this kind of situation is to call Steve or someone like Steve or a window expert to have them come out there and take a look at it.
Right.
If the windows are not functioning properly, it's a problem.
Right. It's usually due to insulation in the windows and insulation in the walls. So you may end up having to upgrade the insulation and change the windows out to stop that problem, and install a mechanical fan. That, as we discussed earlier, that may be that would be the first step that I would do.
All right. The next question is, why does a property owner have to pay for a tenant's apartment that has bed bugs in it when no other part of the building had bed bugs?
Yeah, great question. The answer is that these bed bug situations very difficult to prove who's responsible. Under the civil code, if the tenant is engaging in conduct rather that damages the property, it's the tenant's responsibility to fix it, right? But it's really a matter of proof. It's a matter of evidence. And sometimes the law can be really clear. I mean, the law can tell you if the tenant's fault, then tenant has to fix. If landlord's responsibility, landlord has to fix. It's the gray area in proving that, right? That's and I'm a very practical guy. So I always tell people it's a practicality issue, is how are you going to prove that the tenant caused the bed bugs such that they have to fix it?
So Michael, I'm going to talk about a practical thing. You can fight about the tenant with the tenant later, who's at fault. But if you have bed bugs, you want to be all over it.
Yeah.
Right? Want that to spread. You may have a contest who's at fault, but as a landlord, from a practical manner, you want to get in and deal with it. You do not want that spreading in your building, and it can be a nightmare. It's very expensive. I have a friend that had to do that. It's very expensive, but you need to be on top of it like ASAP.
Right. That's exactly right.
Okay.
All right, next question, Steve, is do you work with insurance claims reps to help evaluate claims, and any suggestions on how to find civil codes to evaluate damages?
Yes, we do work with claims adjusters, and many times we're working with them on pre-litigation matters. So there's a claim that's been made, and they will ask us to opine and give an opinion. I'll give you an example. We had one from a major company. The person slipped and fell and was suing the landlord. And after we reviewed it, they actually slipped and fell in the homeowner common area. And so it saved our client so probably over $100,000 because it wasn't their client at fault. The carrier that needed to be involved was the HOA that controlled the common area. So we were able to determine that, no, you don't have liability. It's really the other guys because they fell in the common area, not on your client's property. So yeah, we do that. We also have done slip and falls where people have put illegal steps in and they've slipped and fell. And when we went out there, the steps were totally illegal and not the code. So yeah, we'll definitely can put a report together and get back to you.
Right.
All right. Next question. If a tenant damages the rental by pulling the carpet, scraping the walls, and the deposit doesn't cover the damages, what should we do if they are paying their rent on time?
All right. This is a question from Judy Kahuri. Hi, Judy. Yes, a great question. So what this is essentially a security deposit question. First, just to keep this brief, if the tenants do damage beyond ordinary wear and tear, and you are going to, and they leave, you have to account for the security deposit within 21 days of the day that they vacate. You do that by writing them a letter that says, here's the amount of security that you gave us. Here's the damages for which we're taking a deduction. Normally, when at the initial, within 21 days, you're sending them an estimate because the work hasn't been finished yet. So you want to attach all the written estimates that you got for that work. If the amount of the security deposit doesn't cover the total amount of damages, then you make a demand for them to pay the difference, the delta there. And you send that off to them in the mail, first class mail to the last known address, do it within 21 days. When you actually get the work done, right, the contractor comes in and he sends you that final bill, you want to make sure that you send that final bill to the tenants. Then they're not going to pay you the damage over the amount. In fact, they're probably going to say there was no damage and you owe me everything back. You then have a cause of action in the small claims court, generally speaking, for the amount of damage that was above the security deposit.
So Michael, I want to counter a common retort. It was like that when I moved in.
Yeah.
Right.
So,
we all heard that. So
right.
one of the things from a practical standpoint, when we lease a property, is there's a move-in, move-out form. And I know if you're a member of California Apartment Association through SFAA or Tri-County or one of the other ones, utilize that move-in, move-out worksheet. So I go through every item. There's a broken tile in the kitchen. It's cracked, right? Or, it's minor, it's superficial.
Yep.
Write a report, take a photo of it, document it, right? And then California has the toughest security deposit law in the state because you have to give their tenant a right to a pre-walkout inspection. You must leave the form, and then you have to do the final inspection. I'll give you an example. I rented a townhouse to this lady and her family. She seemed perfectly nice. Brand new kitchen, everything was new, right? New fridge, new everything. Well, when I got it back, they did all the damage. So I did a really good move-in inspection with photos, and then I documented. So I did photos. I had a brand new stainless steel refrigerator, and they took their bike down and put this huge crease mark down through the middle of it, and we couldn't repair it. So I was very careful. When the documentation went back to the tenant, it was over 20 pages with photos. I circled the damage. They still were over to the security deposit, like $400. I wasn't going to chase them for 400, but I never heard anything from that tenant because I thoroughly documented all the damages. Here's the invoices. Here's photos of things that you did, and you need to pay for it.
Yeah. So Steve, very briefly on security deposits, the number one thing that most people lose in a security deposit fight is they don't follow the civil code. You got to give them the notice of a right to a move out inspection. And then you've got to do the move out inspection if they request it. You have to give an accounting within 21 days. And then you have to send the estimates to them and then follow it up with the actual receipts. But Steve, I hate to do this, but I've got a 12:30 call coming in.
All right.
So I got to run.
All right.
Michael, thank you. We're on
Michael.
our last
Great.
question.
I'll
So,
hang on
so
for a
thank
couple-
you for staying with us.
Yeah, thank you, Michael. It's always a pleasure. Thank you for coming on. I will stay on for a couple more minutes and
Okay, great. Thanks, guys.
thank you, Michael.
See you all later.
All right. Chris, do we have any more final questions?
Yeah, the very last question here. Does a tenant have to pay rent if the apartment is unpermitted/illegal?
You can't give them a 3-day notice. It's arguable if they got some value for it, but the complaint's going to always ask for disgorgement of rent, and they're always going to ask for their money back. So I think there's some argument they made under the Qantas something argument that they got some value for it. So here's my deal. Don't rent out illegal units. They could also get you for fraud. You knew it was a legal unit and you rented to me anyway. That's just it's just a problematic thing, and you're going to end up paying something as a landlord. Any other final questions before we go? I know our speakers, a couple of our speakers had to leave here, so we'll take.
No, that's all for now.
All right. Hey, I want to thank you for joining us. It's always a pleasure. In COVID, we moved to webinars. It's been a little bit different, but I think we're out trying to educate people on our email list. If you need help, reach out to us. There's our phone number, 510-749-4880, or contact us at info@Edrington & Associates. We do expert witness. We do a lot of consulting around accessory dwelling units. If you're looking to add or convert an existing space, or clean up an illegal unit, or add a new building in the back, we work with a lot of that. We do a lot of reports. We have an architect on staff, so we can help you with that. We're also real estate brokers, specialize in apartment buildings, do single family homes and condos. If we can help you, please reach out to us. So with that, thank you for attending, and we look forward to seeing you at the next presentation.